A trust is a private agreement between a grantor or trustee for the benefit of a beneficiary. It's a contract. I'm agreeing to hold this property for the benefit of this person, and you're giving me the rules about it. I owe a fiduciary responsibility to that person what I do with this asset. That's what a trust is. Some people, it makes a little more sense if they think of the trust as a business. Under the law, the way the law looks at it, it is not a separate legal entity, but many people can think of it better in terms of, think of it as though you're setting up a business and you're going to transfer assets to that business, and the business is to take care of that child with these resources. But that's what a trust can do. In Georgia, the grantor, the trustee, and the beneficiary can all be the same person. So I can set up a trust for myself where I'm the trustee and I'm the beneficiary. That's commonly referred to as a revocable living trust. So you might want to set up a trust for yourself, transfer your own assets into it, and then you are the beneficiary. As far as the law is concerned, you still own everything. When you become incapacitated, however, and can no longer function as the trustee, you still are the beneficiary, but whoever you've named behind you becomes the successor trustee. They do not have to go to court to be named the successor trustee. They don't have to file any reports with the court. They don't have to file any accountings. They don't have to ask permission of the court. All of that's contained in the trust document. So this is a very powerful tool in case you become incapacitated. And where that can become important for a special needs situation is you're probably providing a lot of support for your special needs child right now. If you become incapacitated, how is that going to work? How is that going to function? How are your resources going to be used to benefit not only you, but also your special needs child? One word of warning on a trust though, a revocable living trust, you have to have the right kind of assets that can actually be owned and managed by a trust for it to be effective. If all of your assets are in a 401k or in your home, it's not as useful. There are still uses for it, but it's not as useful because those assets usually are not transferred into a trust until you pass away. IRAs, 401ks, things like that cannot be owned by a revocable living trust while you're alive. They can pay to a trust when you pass away. So, that all depends on what your particular estate looks like, whether this is a viable option for you. Trust can be established for yourself, that's what we were just talking about, or it can be established for someone else and can protect assets from creditors. What did we call Medicaid? A creditor. We can create a trust for someone else and then we can put all kinds of rules around it. We can't do it for ourselves. If we could, then everybody would own everything in trust and creditors would never get paid. So we can't do that, but we can take your money and leave it for someone else and their creditors cannot get at it. Your creditors can still get at it, their creditors cannot. Medicaid is your child's creditor.